you are required to understand that there is a requirement of studying the current legal news and views. Current legal news and views. And for that, the best source is your newspaper, which gives you clear idea that what kind of questions may be expected. And I'll tell you the method of this reading of newspaper, and I'll tell you how this newspaper is relevant for raising questions. Now see, in today's newspaper, as I have told you, that see Indian Express, on the very first page they say SC allows PML a verdict review, flex burden of proof, sharing information. In my other class also I read this news item, and I tried to inform my students that see how useful this news is and how it tells you the answer. Now there is a question within this article that PMLA, that is Prevention of Money Laundering Act. Now first, PMLA can be a question of your essay. Many examinations you are asked an essay question. You are asked an essay question. You are asked an essay question. Is this clear? You are asked an essay question. And in this essay question, they will ask you current legal topics. Now what will be this current legal topic? If you start jotting down it towards the end of examination or towards the end of your course, it is not going to help. Or when you are at the end of examination, the examination is at hand and you start doing this is not going to prove fruitful. So what should be done? You start jotting down right now that PMLA is an important topic for aise, legal aise, Prevention of Money Laundering Act. As we are law students, obviously we'll write with that legal color. We'll show that legal acumen. We'll talk about legal information. Let me tell you, my dear friend. Now this PMLA raises some questions. There is presumed guilt. Generally in criminal jurisprudence, this idea is foreign and repugnant that somebody will be considered guilty at the outset. There is presumption of innocence in criminal jurisprudence. But PMLA is a different act. It is strict in that sense that it will presume innocence. It will presume guilt rather than innocence. Then there is a reverse burden of proof. Now see the terminology. Reverse burden of proof. Many of you might have read evidence law. Have you encountered this reverse burden of proof? If yes, well and good. If no, listen to me. Generally, it is whose task to prove this? In criminal, obviously, it is task of prosecution and state to prove the guilt. But here it is not so. Here you are required to prove that I am not guilty, I am innocent. So this reverse burden of proof, be it in PMLA or be it in POXO, many other stringent laws may be there. But these POXO and PMLA are very much in news right now. So there is presumed guilt, and considering this presumed guilt, there is reverse burden of proof that the accused concerned will prove that he is not guilty. This is reverse. Not prosecution, it is accused, it is defense. Reverse burden. Now, then this news item raised another topic. If you read this news item, you will find that on this PMLA they have accepted a review petition. The moment they have accepted the review petition, there will be talk of review on what ground. So now the moment review question comes in your mind, you will refer to the review provision here and there. What is the review provision? In Constitution, you talk of review in Article 137. See, this is how we remember also. Review. Review in CPC, review in CRPC, review in Constitution, review in international law. So now this is the method of memorizing. People will say that I don't remember sections and cases. I will tell you thousands of methods to memorize. How will we do it? If you see CPC review, it is order 47, rule 1. 4 plus 7, 11. If you see CRPC review, it is section 362 of CRPC. 3 plus 6 plus 2, 11. If you see Constitution review, it is article 137, 1 plus 3 plus 7, 11. So everywhere 11. This is how this newspaper takes me to those areas and I raise question and I memorize. This is why I think that you should read newspaper along with your law understanding. I am talking of understanding, not just raising questions and writing something in chat box and doing something. Knowledge of law may be there with many people, but understanding of law is a different thing altogether. When I say understanding, I mean that you understand how to process this information. Now I talked of even this international law. This is Article 61 of ICJ statute. So 6 plus 1 is 7. Now see 7, 7, 7. So I can remember. I read it, I hope, maybe 15, 20 years back, but even today I remember. So this is the thing which we are required to adopt. This is concept building classes, as I have said. So I saw review. Now then there is another question. You tell me, my dear friend, that this review, which has been accepted by the Supreme Court, will be on what ground? Because the ground of review is written here in Order 47, Rule 1. प्लीज हमको सुनिए ध्यान से. आपके दिमाग में बहुत सारे क्वेश्चंस आएंगे हाइपोथेटिकल. मैं सारे सवाल का जवाब दूंगा. ठीक है, आप मुझे ध्यान से सुनिए, आपको सारे सवाल का भी जवाब मिलता है. कोई नोट्स वोट्स बनाने की जरूरत नहीं. न्यूज़पेपर का कोई नोट्स नहीं बनाया जाता. कितने चीजों का आप नोट्स बनाते रहेंगे? नहीं नहीं, कोई जरूरत नहीं है ना. अब मेरी बातों को ध्यान से सुनो. यहां नोट्स बनाना है. हाँ, आप लिख लो ना क्या क्या इश्यूज आज रेज हुए. अब मैंने बनाया पीएमएलए रिव्यू, लिखा बर्डन ऑफ प्रूफ, रिवर्स बर्डन. दिस व्हाट इज नोट्स. नोट्स का मतलब आप वो पे राइटिंग होल स्टोरी. नो. प्रिज्यूम्ड गिल्ट, no information. Now generally whenever a case is filed and if FIR is registered, if you go to police wala and register FIR, then they will give you FIR copies free of cost. FIR copy is given free of cost. But whether this kind of cases which is being done by enforcement directorate, is it required to be, is it required that you should be given information? No, no. So you will raise question that why so? Why no information? This is violation of principle of natural justice. So this is what is the notes. Not like that. You just understand it first and you relate it with your material or with your reading. So the moment you read no information here, so you go to FIR and you say that their information, their FIR copy is supplied free of cost. It's written in section 154 of CRPC. Section 154 of CRPC. Section 154 of CRPC. Section 154 of CRPC. Is this clear? FIR copy is to be given free of cost. Now, in this case, no copy is given. If you see this, matter, in this newspaper, I see page 4. Enforcement case information report. Enforcement case information report, that is ECIR. So, do you give ECIR? No. So, now this is what is relevant for us to understand. I will write here, no enforcement case information report, ECIR. This is called ECIR. Newspaper, I have read and I have told you, no information, no ECIR, enforcement case information report, ECIR. Now, why this no ECIR? That is the question. So, review will lie on these grounds. Now, you know, review is generally done in chambers. That is not in open court. It is done in chambers. Chambers. That is in the office of concerned judge. But here in this case, a review will be done in open court. An exception. Open court. And open court. An exception. So this is information is relevant. I asked a person in interview today. He said that I have read about this in Constitution. He was quite confident. So I asked him this question, that review is done in open or in chamber. So he said it is done in open, but it is done in chambers. But in exceptional cases, it can be done in open. So you understand that when I read newspaper, I am exposed to many issues. So this is why reading of newspaper is very, very important. If you do not do it from the very beginning, if you do not do it 6 months, 1 year, then you may not be now. And reading newspaper will help you to write better also. Your language will improve, your English will be better, your understanding of law will be sharper. But then I find another case in today's newspaper. This was on page 4 and this page is page 4, so it starts from page 3 in that sense, no? Page 3 and page 4. The first page, because there was advertisement on the front page. That is why they have written like this. Advertisement on the front page, and the second page, advertisement. Advertisement. There is advertisement. PMLA verdict. Now then Bilkis case. Now, if you read Bilkis case, again you have or you will come across many issues. What are the issues? First issue in Bilkis case was transfer. Transfer of case from Gujarat to Maharashtra. Now you may raise a question that where is this power of transfer? There may be various provisions of transfer here and there. In CPC it is in section 25. In CRPC it is in section 406. And even in this constitution, it is in around this 139A. If I remember correctly. So what is transfer? Where are the transfer provisions you have come to know? Because there was transfer of case and transfer was an issue. A case was filed or this was decided by the Supreme Court. That who is entitled to remit the sentence? The Gujarat government or the Maharashtra government? Supreme Court said that this is case of Gujarat, though it has been transferred to Maharashtra. So, but Maharashtra government is not entitled to award remission of sentence or punishment. It is basically the Gujarat government. The government against or who had jurisdiction in the case where the crime was committed. Where the crime was committed. So it is Gujarat government which is competent to decide this remission matter. Now, then there is another issue in Bilkis case. That they decided remission matter, but they followed 1992 policy, they did not follow 2014, the new policy of Gujarat government itself, where it has been written in an annexure that no remission will be allowed in murder cases, in rape cases, in gang rape cases, but you allowed this. You allowed this. So that is another query. Is it justified? Should you exercise your power to defeat the whole purpose of law? So the moment you read the case or the news item related to law, you are exposed to variety of matters. Now I saw another news item in today's newspaper, where I found, I'm not saying that in newspaper you read everything, you read just legal news. I saw that there is question of charging some police officers for custodial death. Now custodial death is a major problem, that there are many deaths in custody of police. There are many deaths in custody of police. Now as this is death in custody of police, so here the custodial deaths investigation, inquiry, whatever inquiry is done by the magistrate, will be done by magistrate, not by police wala. Section 176 of CRPC says that. So now you read newspaper and you come to know this. You refer to the section concerned. You have so many terms, so many news coming in your newspaper. That it will be really very, very fruitful for you if you read these news items carefully. Now then there is an editorial also in today's newspaper. Many things are written. August 25 in court, introduction of a strict timeline and a categorical assertion of consent will hopefully endure. The court has been roundly criticized for its selective manner of listing, and this is rightly seen as an institutional failure. Thus, the development over the past few days have come as a pleasant surprise. By a notice of August 24, the Supreme Court has announced a list of 25 out of 53 constitutional bench cases that will be taken up for hearing from August 29, which would be the first day of Justice U. Lilith presiding as Chief Justice of India. So they have taken 25 important cases. Now, these 25 important cases out of 53 which will be heard by the Honorable Apex Court, I think will be most important cases for future examinations. Let us watch them with all attentiveness. Let us be cautious, careful in watching and understanding the decision of these cases which will be heard by the Constitution Bench. Now you are using the term Constitution Bench. Many of you may be aware, some of you may not be aware, that Constitution Bench is 5-judge bench. Authority comes when the number of judges are more, because there have been more people to take a call on the point. If decision is given with unanimity, it is far better. But decision, even if it is by majority, it will be held binding decision. So this is how, now after Indira Sahni ruling of 1992, which allowed OBC reservation in jobs and education, but rejected the use of economic stratification for such quota, the constitution was amended in 2019 to bring in a maximum of 10% for the economically weaker sections. The validity of this is a part of list and awakens interest, particularly as it leads to a different political directions for age-old quota debate. Among policy decisions, demonetization has been by far one of the most controversial ones in India's recent history. Its validity comes up for consideration as well. Although, as with the Andhra Pradesh bifurcation, very little survives in the real world. The Supreme Court had directed that no petition would be entertained by any High Court, which led to all others being solicited at Tilak Mark. Only those who have old notes which were not accepted for swapping may have something to expect here. Okay, whatever it is written. The rent control laws of Bombay. Many important issues are there. They have mentioned, bear in the mind that Article 136 of Constitution allows anybody to file a challenge to the Supreme Court against any order or judgment of any court. See, they have also said, in recent past, such benches have delivered verdicts on Aadhaar, privacy reservation, judicial appointment, temple entry, gubernatorial power, land acquisition. Of course, they are all important and most of them have been warmly welcomed. But equally, they have been prioritized for hearing over cases that have been languishing for decades to be considered. So now the question is why we have given priorities to this? Why not we are taking up other cases? Then there is many other issues, that Revadi culture, freebies. Now is it going to serve us very well? So these news items will expose you to variety of questions which are being raised. You see, law doesn't operate in vacuum. Just reading the books and the acquisition of some knowledge will not help you passing the examination. If you want to really pass the examination, you are required to be quite abreast with what is happening in and around you. It should not be that you are just reading the books and acquiring some knowledge of sections and cases. This is not a study of law. Understanding of law does not operate in vacuum. It operates in real world, and real world has several issues before you. So just keep track of that. and must read legal news every day without failure.